everyone. You're watching A Billion Ideas with me, Maria Shakil. The standoff between the judiciary and the government over appointment of judges has taken an ugly turn. The apex court has released publicly the objections of the central government to the elevation of 5 advocates to the post of judges. The top court uploaded the letters to the centre, publicly refuting its objections and even criticized the Justice Department for repeatedly sending back the Collegium's recommendations. The Supreme Court has also countered all the government's contentions over the statements, social media posts and even sexual orientation of the candidates in public. This comes days after Law Minister Kiren Rijiju wrote a letter to Chief Justice of India, D.Y. Chandrachud, and asked him to include government representatives in the Supreme Court Collegium and a state representative in each of the High Court Collegiums. As the centre continues its campaign to reform the Collegium system, appointments to key judicial posts seem to be caught in limbo. So the big question is, in fact, there are several questions that arise out of this. Who is crossing the line? Will there be judicial reform soon? And what really is the Collegium solution? So let's get you an overview of the last impasse between the centre and the judiciary. I would say the latest impasse. First, there is Advocate Saurav Kirpal, recommended to the Delhi High Court. The government's contention is that Kirpal's partner is a Swiss national. The Collegium's counter is that many spouses of constitutional office holders are foreign nationals, and the country of origin is a friendly country. Now, point 2. The government's contention is that Kirpal is open about his sexual orientation. The Collegium's counter is that citizens are entitled to maintain dignity and individuality. The advocate, the Supreme Court says, has not been surreptitious about his orientation, and he will provide inclusion and diversity to the bench. Then there is another advocate, Advocate Somasekhar Sundaresan. He has been recommended to the Bombay High Court for the elevation. The government's contention is that he shares his views on social and traditional media. The Collegium's counter is that all citizens have right to free speech and expression. And the man in question here is a man of competence and merit. Then there is Advocate R. John Satyan, who has been recommended for elevation at the Madras High Court. The government's contention is that he shared an article critical of Prime Minister Modi and shared an article on a NEET-linked suicide, calling it a political betrayal. The Collegium's counter is that the IB report notes he has no overt political leanings, adding that sharing articles does not impinge on suitability, character and integrity. Then there are advocates Amitesh Banerjee and Sakya Sen, recommended to the Calcutta High Court. The government's contention is that IB inputs cite the candidates as unsuitable. The recommendations were sent back to the Collegium 3 times. The Collegium's counter is that inputs have no fresh material or ground to deny appointment, adding that it is not open to the Justice Department repeatedly sending back proposals. So with the executive and the judiciary on collision course, can this judicial appointment be reformed at all? Joining me on the show, Tanveer Ahmed, senior advocate. Professor Faizan Mustafa, Vice Chancellor of Nalsar University, is joining me live. We also have Namit Saxena. He's a lawyer and he's a Supreme Court lawyer, and Rekha Agarwal, advocate of Supreme Court and activist. Faizan Mustafa, we are looking at unprecedented times, and it is also ironic, sir, that Justice Verma, who was the author of the leading judgment in the second judge's case, which gave a tentative shape to the collegium system of appointment of judges in 1993, after the passage of time, in fact, had found fault in the working system and had gone to the extent of saying, and I'm quoting him, where he said that judicial appointments have become judicial disappointments. Do you see this as judicial disappointments when these elevations have happened?
Maria, first let me correct you that I have demitted office at Nal, sir.
Okay, sir. So it will be former Vice Chancellor. Okay.
Former Vice Chancellor.
Okay, I'll ask my team to correct that. Apologies.
Now, I would not go to the extent of saying that the collegium appointments have been sheer disappointment. Okay. There have been disappointments here and there. But Justice Verma, who was a very, very eminent judge, and I had a very affectionate and personal relationship with him, and he was always very, very affectionate. You know, about his Hindutva judgment also, he said that I did not mean how people have concluded that this is what the law which Supreme Court has laid down. So sometimes it happens that when a judge lays down law in a judgment, subsequently as that judgment is implemented, we see that probably this was not the right thing to do. You see, I have written a number of times that if you look at the Constitution, Article 124, it prefers wider consultation. The problem with the collegium system is it does not give any role whatsoever to the high courts. Now the government is saying that there should be some government representative even at the level of the high court. But if you look at the original 124, the President of India may consult even high court judges in the appointment of Supreme Court judges. And I think there is a great wisdom in it because many Supreme Court judges must have worked in high courts and their brother judges in high courts may have formed some opinion about them. So I would say that there are arguments in favor of collegium. There are arguments against them. There are some appointments about which one may question that these people should have been appointed earlier. At times, the seniority in the name of merit was also compromised.
That's right.
But you see, government makes most of the appointments. Okay. Can you say all appointments made by the government are absolutely above board and fair? So I always, believe in the middle ground. And my middle ground is, while it is understandable that for the independence of the judiciary, ideally the judges of the Supreme Court and the judges of the High Court should be involved in the consultative process for the appointment of judges. And therefore, probably the collegium system in the given circumstances is not all that transparent. But at the same time, I would say to completely exclude government from the process of the appointment of judges
may not also be fair. All right.
And it does not happen in any other country in the world. And consultation should not be interpreted as concurrence. But the independence of judiciary is so crucial that with government having over 80% of cases, there is a concern that can somebody pick up judges, can one be a judge in his own cause? And that's why, this whole idea of the collegium was born. Definitely, it was an era of coalition governments. And during coalition government, Supreme Court really asserts itself a lot.
Okay. So, Tanveer Ahmed Mir, one thought certainly is that judicial appointments have been linked to lack of transparency and about nepotism. I read this article which said that every third High Court judge is an uncle because at least 16 or 34% of the 47 judges in the Punjab and Haryana High Court have kith and kin practicing law at the same place. And until 1961, sir, in India, there were instances in which lawyers appeared in the same court, over where did not appear. And then there was, there were certain rules that, there should not be the lawyers should not appear in courtrooms where their uncles and relatives practice. But that is no longer there. So that nepotism charge does really hold, right?
No, Maria, the nepotism charge doesn't hold at all. I tell you why. It's very simple. Any person belonging to any family background may choose a career. Now, just because a relative is also a practicing lawyer is tomorrow appointed as a judge. One may be in the district judiciary, one may be in the high court. That doesn't mean that a kith and kin should be knocked out of the profession lock, stock and barrel. But maintaining probity is a matter of individual consent, which means that if a person belongs to kith and kin or is an heir in it, obviously he will never appear before a judge who is related. You know, sometimes what even happens to us is that if we are from same chambers, the judges will obviously recuse and send the brief, transfer the brief to another brother judge. But we cannot take this just because some lawyers are there who will be related in one way or another to judicial community. We can't say that this is nepotism, lock, stock and barrel. Secondly, the issue with the government is, let me flip over the coin for you. When it comes for the government to appoint government lawyers, be it in the Supreme Court, be it in the state, be it in the high courts, be it anywhere else, do they appoint lawyers on merit? No. They appoint lawyers on political favors. As simple as that. Most of the lawyers you will find who are appearing for the government are through some connections.
Okay.
So you don't go to a meritorious exercise.
Okay.
So when you ask that I must have a say in appointment of a judge of the High Court or a judge of the Supreme Court, what are you trying to say? You know, our system works on a concept that the judges will not interfere in the work of the executive. No High Court judge, district court judge, or a Supreme Court judge says to a political dispensation who to appoint as a governor, which police person is to be appointed as a commissioner, or even an SHO of a police station. That's your domain.
Okay. So,
as far as appointment of judges is concerned, for manifest independence of judiciary,
it should be left
as the last bastion for the society to seek justice. The least what we can have is politicians bulldozing themselves, because what the political community at the end of the day will want is that their people, purely on political affiliations, be included, so that subsequently after appointment they be taken care of.
Okay, then and in that case, okay, just try and help me understand, Rekha Agarwal. You know, this concept of uncle judges, brother judges have become uncle judges. You know, that there is a problem here, and I'm trying to make an argument with what former judges have themselves said. Justice Bhagwati, who expressed his dissatisfaction with the existing mode of appointment of judges in India, in which they were selected, he had famously said that in a single individual, that is the president, whose choice may be correct or inadequate and may also sometimes be imperceptibly influenced by extraneous or irrelevant considerations. Therefore, he considered it unwise to entrust power particularly to make crucial and sensitive appointments such as judicial appointments to single individual. So then how do you ensure checks and balances if this is the response that comes from the judiciary, with the Supreme Court putting out all the contention that the government had in the public domain?
See, what I would say over here is that, you know, there has to be a balance. And as the previous speaker said, that we have to see a middle ground. So I'm not totally in favor of the collegium system, and nor am I against it, because I do think that it is the collegium which has the best knowledge, you know, the internal knowledge as to which lawyer is qualified, you know, to be elevated as a judge. So I think that, one cannot do away with the collegium system totally, but I fully agree with what Justice Bhagwati also said, and there is merit in what the Honorable Judge had said, that we cannot just, put the entire power in one person and think that it is the President, who may have the right to interfere. So, as that old saying goes, that all power corrupts and absolute power corrupts absolutely. So I think that this entire power of appointing any judge should not be given to the collegium, and the middle ground has to be found. There has to be a balance, and that balance can be by limiting the there should be an involvement. In my personal view, there should be an involvement of the government to some extent, because if you are giving the power totally in the hands of the collegium, you are putting your entire entire thing is in the hands of a few judges, the 5 judges who are in the collegium. So I think that instead of just putting the entire burden over there on the collegium to decide, and then we have the situation as we are seeing right now in the case of Saurabh Kirpal and the other 2 judges of Bombay and Calcutta. I think that the collegium should not be given the extent of powers which they are invested with as of now, and let the collegium decide. But a balance should be drawn, and a representative of the government in whatever manner should be involved, as a part of the deciding process. And the views of the government should also be taken, because here I do not agree with putting all the eggs in one basket, and we are putting too much pressure. I think that the collegium system is enjoying too much power, too much authority, and the government also should have some percentage of say in what the collegium decides.
So you are of the opinion that
of power
that there has to be power sharing that has to happen here, in which the government should have a say
between the government and the collegium. Yes.
Namit Saxena, which side of the debate are you on?
Yes.
See, we have to understand this. See, collegium appoints judges to the constitutional courts from the High Court, who may potentially come to the Supreme Court later on. The collegium is not supposed to be a gymkhana club where members will appoint members and members will issue a minutes of meeting that, that this is the criteria, what was the opposition regarding a particular candidate, and this is why we are recommending this candidate again. See, it has to be transparent, but it should not be over transparent. What has happened now is, they have declared a particular sexual orientation of a particular individual. I don't know without, taking his consent or not. And they have, declared that this particular individual is in a relationship with a foreign national. Now, tomorrow, if the government shoots back and, shares sensitive information from IB or from whatever sources they have in public domain, like the collegium system has, this can, lead to, a different ball game altogether. So collegium is not something which is beyond criticism. This doctrine of independence of judiciary, there is no antidote that you inject judges everywhere and judges are holier than thou. And because judges are there, so, independent judiciary is there, and this is completely now immune from all sorts of criticism. And this is a perfect system now. See, collegium system carries, as you have said, nepotism. It carries, accountability. Now, for example, this 3-page statement for Mr. Saurabh Kirpal, which has been released in public domain now. Now, there are no views invited by public. There is no accountability. You can't challenge whatever collegium has said. Now, there is a judgment by the Supreme Court which says that you can't even file an RTI and get whatever information they have. What is the source of this information? So these are all aspects which are to be looked at. Secondly, and most importantly, see, government is a very important stakeholder. See, elected government can't be shrugged off simply saying that you are politicians and your interference will dilute independence of judiciary. So this is something which needs to be looked at from a wider perspective. And see, we must remember Article 124 says President shall appoint judges, in consultation with the Chief Justice of India. It's not Chief Justice of India will appoint judges in consultation with the central government.
Fine enough. Tanveer Ahmed Mir, that's a point very well taken, that the recommending authority should be more broad-based and there should be more wider consultation. And why shouldn't this process of collegium be questioned at all? And why should the government not be a stakeholder here?
Government cannot be a stakeholder in appointment of the constitutional judiciary simply because we are on a tripod here. The tripod is that the judiciary shall not interfere with the executive in their day-to-day affairs, in their appointments, in the manner they place their postings. Similarly, we cannot hand over to the politicians a patent to interfere as who will be a judge of the Constitutional Court. We must understand that, no system will be perfect at the end of the day. But when the Collegium selects judges, what they look at is people with great credibility, expertise in law, and there may be many. So all of them can't go to High Court, all of them can't go to Supreme Court. Now you can have, a myriad argument that, no, this person was better than that person or that person was better than that person. But the criteria in the minds of the judges is that this guy, this gentleman or this lady will come to the court, will serve the society, will be virtually a monk. The judges, are even barred. They can't even go for normal public relations.
No, but Tanveer Ahmed Mir, if you look at it from this point of view, that the judges are looking at them from this kind of prism, then why have constant objections to what the government is saying? My point here is that if it is an improved system, then it can have a better mechanism. Why should existing political dissatisfaction with the present appointment of system be seen as political in nature?
Kindly see the objections which are coming from the government. The proved problems which happen in political dispensations of any orientation. I'm not saying political dispensation A in power, B not in power, or you go to the past or you go to the future. The political establishments always have a problem of appointment on total non-merit considerations and only on political affiliations. Whether you want to see standing councils, you want to see AGs, you want to see anybody, you can
So you're talking about law officers and also the judges.
Well, obviously. Therefore, if you now please see the objection. When you see a government objection, ask those objections by any stretch of imagination, even tenable to common sense.
Fine. Let me give the final words to Professor Faizan Mustafa.
Can you object to a person like Saurabh Kripal? A man who studied in Oxford and Cambridge should not become a judge of the High Court.
Professor Faizan Mustafa,
because of his sexual orientation.
Professor Faizan Mustafa, the idea is also about a better system. And what can be this better system?
No, there has to be some kind of modification in the existing system. But let me just set the record straight. To say that in the current system, government does not have any say is not right. Government sits on recommendations for 5 years. Government does not approve the recommendations, and then the collegium drops those names. You can recall that a lawyer of Gopal Subramaniam's eminence had to be dropped because government had some reservations about him. Several other names come to my mind, which collegium had recommended, and then subsequently collegium did not insist. Now, the memorandum of procedure as it exists today, because let us come to the law, it says if the collegium sends recommendation and government sends objection, then if the collegium reiterates the recommendation, government is bound by it.
Yes.
I see no possibility of government conceding on some of the names which are under discussion right now. And therefore, you are having a kind of a tussle going on between the government and the judiciary. And as I said today in the Indian Express, that probably in the light of the statements made by some of the senior constitutional functionaries, Supreme Court thought it fit, or the collegium thought it fit, to pick up this issue on which they may get wider support of liberals and the human rights defenders and the civil society. But I have also written that maybe it is a trap in which the collegium has fallen, because government can always go to the masses and say that these are the people, who are trying to go against the traditional majoritarian ideas of the morality. But my take is that both government and collegium had no choice in this matter. Government cannot be that liberal that it will accept, for instance, people of different sexual orientation, or the way it has worked so far. Even slightest criticism of the government, would be noted. And the collegium cannot go against its own judgment, a five-judge bench judgment of 2018. So both have stuck their guns. One is talking of constitutional morality, other is talking of the majoritarian traditional morality, and maybe the masses this time round.
So let's see, Professor Faizan Mustafa, what really is the way out, because it looks like that this collision course that they are on, there has to be a solution, but who will really propose that solution? That is something that we'll wait and see. Tanveer Ahmed.
So, Maria, it is in the hands of the government. If they want, they can bring it a new version of NJC, or the collegium may accept some of the government suggestions.
Okay.
It can be resolved amicably as well.
Okay, let's see how it really proceeds, because, you know, with all these, contention being put out in the public domain, I'm not too sure if the Law Ministry has taken that very well. Thank you so much for your time, Professor Faizan Mustafa, Rekha Agarwal, Namit Saxena and Tanveer Ahmed Mir. But that's all from me. I'll be seeing you next week with another episode of A Billion Ideas.